May I permit one writ petition, Your Lordship? The writ petition was dismissed on 4th of November 2022. Then your petitioner have preferred an appeal. In this appeal of this month of 19th September, presided over the Justice Subhasaji Bhattacharya was observed that the writ petition should be reheard and re-adjudicated on merit and listed before this bench, Your Lordship. Here is the order, Your Lordship. Order for appeal. Much obliged, Your Lordship.
2 motions and 1 resolution.
2 motions.
Lordship, may I be permitted to mention 4 premises in attacks matter. Toward admission and toward hearing. Like 1 CRR matter also.
CRR, I don't have determination.
For hearing, my lord.
I don't have any determination, madam.
Huh?
Yes.
Another motion.
Item number 1.
Respondent number 1 and 2.
Where is the petition?
I informed him yesterday, my lord. Mr. Arjun Chaudhary is appearing for the petitioner, my lord. He usually practices in the criminal side, my lord. He told me that he will come today, my lord. Now
Where is he? The matter is called now.
this matter is pending since 2021, and there is nothing in the matter. State has also submitted the report.
What is the matter about?
My lord, the petitioner. This Mr. from service. My school is a unaided private school. Private school.
Unaided private school?
Yes, madam. And his service was purely temporary, contractual in nature. And he was under probation period, and as per the management rules, his employment can be terminated without notice. It is there, madam.
What is that rule?
Yes, it is annexed with the.
What is the termination order? Where is the termination order?
If you also kindly comes to him. Well, if you also kindly comes to page 27, this is the contract for service month. First month. And the legible copy is at page 27A.
Show me the termination order.
Yes, ma'am.
During the probation, he was terminated.
Yes, did. He has not enclosed it. He has not enclosed it.
This is affiliated, the school is affiliated.
Last 51, madam. Page 51, madam. Page 51.
What is his appointed?
Same position.
Appointed
Damage.
Appointment ballot page. Ballot page 27. Page 27. And page 26, madam. 26, 27. No, that is something which has manufactured, madam. Because it was manufactured during the time of lockdown when there was no committee at all. The earlier managing committee was continuing, madam. In
2019, he was appointed.
Yes, madam.
And terminated on?
Terminated, madam, page 51, madam. Terminated on 2020.
10th of
August 2020.
What is the probation period?
Madam, if you also kindly come to page 27A, this is the type copy of the contract of service, madam.
Yes. What is the probation period?
Paragraph of point number 1 and 2, madam. Point number 1 and 2, madam.
Probation period of 1 year, but he was terminated after 1 year.
Yes, madam. It can be extended for till 2 years, madam, because there was a lockdown, madam. Hence, he could not be terminated, madam. And he started making derogatory comments against the president, ballot, For that reason, he was, complaint was also lodged, my lord, against him.
Did you extend this probation period or not?
My lord, since there was complete lockdown during that period, hence he was not terminated from the service, my lord. Subsequently thereafter, it was done. Okay, permanent. Provisional জন্য এখানে no notice. Clause number 2.
What was the date? First,
Date of termination was.
no date of agreement.
Date of appointment, my lord, 1st April 2019.
19 and termination.
10th of August 2020.
20.
You have not extended this probation period, so it cannot be said that during the probation he was terminated.
And my lord, if you also kindly seize my opposition.
Yes,
If you also kindly seize my lord, opposition. He claims that in the month of April, a new committee was formed. And that committee has extended has made him post permanent, my lord. My lord, my contention is that if you also kindly see page 12, annexure of my opposition, my lord, R1.
page 12.
Yes, my lord, R1. My lord, since the school is under the control of the Bharat Seva Sangha, my lord, Sevashram Sangha, my lord, communication was made to the committee which was valid till 31st of March 2020. Due to lockdown in the country for continued 4 months and may continue for 2 to 3 months. More, you are advised to act as secretary of the Pranananda Centenary Sikshayatan to run the school till further committee is approved by the governing body of Bharat Sevashram. Thereafter, my lord, if you also comes to page 13, complaint was lodged before the officer in charge, Rajganj Police Station, my lord, against the conduct of the teacher, my lord.
This is for default.
Grateful.
Leak also. When the matter was taken up for hearing yesterday, no one appeared on behalf of the petitioner. The learned advocate appearing on behalf of, you're appearing for?
I'm for the respect of 1 and 2.
Respondent number 1 and 2 submitted before this court that for last many occasions. On several occasions, the petitioner did not appear when the matter was called on. Next panel. Today, the matter was fixed under the heading to be mentioned. No one appears on behalf of the petitioner even today. Accordingly, WP number 13 such decision should be found.
Grateful.
My lord, I seek one indulgence from your lord. My lord, there's a very urgent matter come up.
Urgent?
Very urgent, my lord. My petitioner used to run a hotel in Siliguri since 1963. In a fire in this year, February, it got gutted.
What is the listed matter?
No, my lord. The corporation will,
Where is the matter?
my lord, it has been filed yesterday, my lord.
It will be listed. What is the problem? Tomorrow.
My lord, tomorrow is the last date when the corporation will demolish the structure. So I'm praying for a stay on that.
But the matter has to be listed.
If my lord is kind enough to
So
take out
tomorrow
the,
this will appear. You give it.
but in the meantime, they may destroy tomorrow. That is the,
Tomorrow is the date you are
Lakshmi.
saying. Have you served notice?
we have served, we are serving it right now. Good, state has been served and
But
corporation.
unless the matter is listed, how it can be taken up for you?
If your lordship will be kind enough to,
How? Non-listed matter cannot be taken up.
so my lord may be kind enough to direct it to come at the top of the list tomorrow.
Tomorrow this will appear. You give it matter will be called on.
Yes,
Tomorrow
my
this will
lord.
appear. অত দরকার নেই, WP number such and such, together with can is dismissed.
Lordship, in this matter, I am for the state respondent. Lordship, this is the matter of general transfer of the teacher. But Lordship, in this matter, Madrasa board is the answering respondent. Because the teacher is belongs to Madrasa school.
Yes, Madrasa is not giving you an objection.
Lordship, then. Lordship, then, we don't have any problem,
You
Lordship.
are appearing for whom?
We are for state, Lordship.
No, the Madrasa, who is for the Madrasa? Where is the petitioner?
I don't know, Lordship.
Subhrangshu Mani is not appearing.
This matter is pending since 2020-21.
Kalki to mention it now.
In the year of 26th day of April, they have filed a supplementary affidavit. After that, they did not.
Very well, tomorrow to mention. এই যে অর্ডারটা আছে, অর্ডারটাই মোটামুটি হয়ে যাবে কালকে, যদি না কেউ appear করে।
Well, I mean, the state response.
Yes, state, first of all. কেউ না থাকলে
Lordship, Lordship, in this matter,
Municipality.
Lordship, I am appearing for the petitioner.
yes, 5 দিন।
I'm appealing for the
Yes,
Lordship, on 2021, a tender was issued by the government of West Bengal for construction of boundary wall under the Greeneries Mission, encroaching the petitioner's land. Now challenging that tender is page 61 to 64. Now challenging that tender, Lordship, petitioner moved and did petition earlier before the Honorable High Court, and wherein by the order of Honorable Justice Rajasekhar Mamta, the order is at page 78. The respondent district magistrate was directed to consider the petitioner's representation with demarcation of the land. Now during page 78 to 78A is the order, Lordship, the earlier order. Now in the midst, thereafter petitioner communicated all the order sheets, because in the land there is a long-standing battle with the government of West Bengal. With the earlier order is there, stay order is also there, earlier writ petition on the different cause of action. Now subsequently during the hearing, Lordship, it appears petitioner make a representation that the land must be demarcated in terms of the order of Honorable Justice Mantha, which was passed on 29th March 2022. Regarding that aspect, they also wrote a letter to the district magistrate, that is the page 86 and thereafter, Lordship, page 86. Now after that, Lordship, without and from the order itself, Lordship, the subsequent in the midst of the hearing from the order itself, it appears that the demarcation of the land is made by the district magistrate by demarcating the petitioner's land. So petitioner asks the demarcation report and to contest in the hearing before the district magistrate. But in spite of their request, no demarcation report is given to them. So Lordship, only I humbly pray they let no final order be passed in the subsequent hearing, and demarcation report may be handed over to the petitioner so that they properly can contest it in the matter before him. This is the sole prayer of the Lordship.
yes,
My lord, several hearings were given in pursuance of the order of the coordinate bench of this court. Several hearings were given to the petitioner on, particularly on 18th of April 2022, thereafter on 11th of May 2022, thereafter on 26th of May 2022, 4th of July 2022, and 17th of August 2022. None of the representative of either the petitioner or the representative of the petitioner appeared in the same hearing.
well,
What
we
they-
file
Not correct.
You filed any affidavit?
No, my lord, the affidavit has not been filed, but I have a copy of the report of the concerned state.
You didn't appear.
No, Lordship, there is a record I can show here and now, Lordship, that I have appeared, and Lordship kindly have a look on my written mail, Lordship.
When does you do it?
I'll file.
Let them file affidavit.
Yes,
And in the meantime, Lordship, no construction on the land should be made.
yes. The state shall file an affidavit in response to the allegations made in this writ petition within a period of 7 days from date
Lordship.
with an advance copy served upon the petitioner. Next para, release this matter after 1 week under the same meeting.
That I am happy.
Lordship, some interim protection because they are trying to construct the boundary wall on the land. Lordship.
Appear, you are avoiding of it.
Although my lord, the answering respondent is DF.
Very well.
My lord,
You give your appearance?
Lordship, I don't have to file any report, Lordship.
No, you need.
Great.
Number 6.
My lord, item number 6, I am appearing virtually, my lord. Item number 6, I am appearing virtually, my lord. But this is a transfer matter. My lord, this is a transfer to school teacher matter. Yesterday, my lord decided to 3 matters. But I am paying same benefit. Only, my lord, some correction. Mr. Banerjee is there. Only some correction.
I have already served upon the response petitioner, Lordship.
Yes.
Yes, yes, same thing is happened, my lord. Same paying and same benefit. It is a fresh consideration by the DI and my lord according.
Why fresh? The earlier one has been rejected by the DI. What is the ground?
Ground is my lord, it is not sustainable, my lord. I am showing one division bench order. My Mr. Banerjee, please show Piyush Kanti Das. Kindly show Piyush Kanti. I am relying on division bench order. Piyush Kanti Das, my lord, it is very recent, 25th of July 2023.
Yes. Is your pair has your pair been rejected by the DI or not?
Yes, yes. DI rejected, but separate, my lord. Only, my lord, I am relying paragraph number page number 2. My lord, I am reading out that point. I am relying on a simple benefit of that. I am relying. This is the change of charter. However, it appears that head of the institute rejected that application on the ground of single teacher. It is now well stated that single teacher may not be a ground for deny the transfer if the petitioner failed to fulfill other conditions. This portion, it is come from the division bench order. Relying that order, take a fresh decision. I am sitting there before your lordship that much.
The DI has rejected your plan.
Lordship, internal page 4, Lordship, the general transfer rule, it is settled position that the school authority cannot forward application received from more than 10% of.
What are you reading?
Opposition, page number 4, para 7.
After considering all the rule, my lord, this is the latest position of the division bench order. I am relying that order. My lord, my lord.
There are only 3 teachers. If they send 1 teacher, it will be 33%. They cannot recommend more than 10%. That is the ground.
Yes, my lord, 10%, but it is now as per division bench order. If the teachers fulfilling all the necessary criteria, there is no bar. My lord, authority is duty bound. Authority is duty bound to, my lord, to appoint some teachers to that place. This is the concept of local arrangement. Now reallocation policy has come. Change circumstances has been changed. There is a 10C power of the school authority. After my transfer, they can reallocate another teacher to that post.
Where is the division bench order judgment?
Lordship, I have handed over.
Yes. Paragraph number 2, my lord. Page number 2, paragraph number 2, page number 2. However, it appears that the head of the institution rejected that application on the ground of single teacher. It is now well.
Stop all this.
Lordship.
Even Lordship, in nearby school, there is no substitute teacher.
No, single teacher is one issue, 33%, 10% is another issue.
No, my lord, 33, 10% is not, 10% is wrongly, my lord, single teacher is the main issue. My learned friend relying that document is to only single teacher. There is an embargo, local arrangement. I am only praying before your lordship, give me liberty to file a fresh, relying this division bench order. It will considered by this matter, nothing more. Nothing more. I am only praying that.
Unless you show me that this 10% policy is no more there or it doesn't stand in the way.
Yes,
then
my lord, 10%, my lord, there is a judgment of Prapti Chakraborty. My lord, to Prapti Chakraborty, there is a judgment. It is well settled that 10% is also not a bar. I am telling you, lord.
What is the
My lord, Prapti gentleman, pass it over. My lord, I am showing also Prapti Chakraborty is there.
not today?
Seven.
Lordship, I am for the respondent national highways. Lordship.
Lordship, 7 to 10, I am paying for Passover.
In item number 11, lordship. In item number 11, lordship, may I have your lordship's kind leave to participate in the virtual court proceedings, lordship, from principal bench?
Yes. Who is on the side?
My lord, I am for this.
Lordship, the petitioners are excluded from the purview of promotion from Anganwadi helper to Anganwadi worker, lordship. What happened? They have gained maximum experience of 13 years working on and from 2007. What happened, lordship? After the notification is issued and after the selection list was made, it is seen that all the 72 candidates who participated in the written test examination without any shortlisting and or scrutiny, all are allowed to appear in the viva. And thereafter, lordship, a select list of 28 candidates has been published by the Child Development Project Officer. Lordship, the petitioners who gained the maximum experience, lordship, they are excluded from the purview of promotion and they were awarded, lordship, disproportionate marks in the written test examination as also viva and in the seniority and number weightage. Minimum marks was given in the seniority, lordship. Though they gained experience more than 13 years, lordship.
Yes, have you filed any affidavit?
No, my lord, affidavit has not been filed. I have a copy of the report, my lord. Takes up the next page of the report. But there, my lord, will find the names of the petitioner and the marks awarded to the petitioners in the examination concerned. My lord, what has happened in this case is that in this circumstances, in this particular recruitment process, there was no quota for physically disabled candidates. So the persons with disabilities candidates were treated.
File a report, give them a copy, give them a report, give them a copy.
My learned junior is there, lordship. Matun Chakraborty is appearing with me.
The state shall file an affidavit, the state shall file a report.
Report in the form
of an affidavit with an advance copy summed up on the petitioner within a period of 2 weeks from date. Leave this matter after 2 weeks under the same meeting.
Grateful, lordship. Item number 12 is also similar, Lordship.
Similar.
Let the 12 be called.
Number 12.
Report the copy.
Yes, same order. You are also appearing in 12?
Yes, ma'am.
Same.
Services. 15.
I'm grateful, Lordship. Lordship, leave may be granted to file the exception after handing over the reply, Lordship.
Come, you consider the report, and if you find anything meritorious, then you file the exception.
Lordship,
The report you have failed in the written examination.
obliged, Lordship.
Number 30.
In a 40 Lordship, I am for the respondent
First of all,
authority,
first of all.
Provident Fund Authority.
First of all,
First of all. 13 and 40.
Number 15.
15 Lordship, I am for the petition. Lordship, kindly excuse me for the virtual mode. Lordship, this is an application for unauthorized, against the unauthorized construction. Lordship, kindly come to page 25.
other side is not here. First of all, yes, yes.
Lordship, affidavit, my clerk is present, affidavit service is there. Lordship, kindly come page 25.
Don't take so casually. Your clerk cannot file him in that with the High Court. Why are you taking High Court so casually, Mr. Mukherjee? Your clerk will
Lordship, I will request my learned junior to hand over the.
not today. Not today, not today.
Mr. 16, yes, my lord, 16, I am for the petitioner, my lord, I am appearing virtually. 16, lord, I am for the petitioner.
Yes.
My lord, this is the matter of a general transfer of a lady teacher who is suffering by various ailments. My lord, it is admitted position, there is an embargo of 5. My lord.
Last time I rejected already.
No, it is pending. It is pending, first time. It is pending. My lord, what happened? I am relying on decision of division bench, that is Shubhadeep Gorai, MAT 782 of 2023. This is the latest judgment. Mr. Banerjee, please give the judgment.
Where is the other side? Not today.
Not sure.
Not today.
Not sure.
Seventeen also.
17 million, I am for the petitioner. I don't know where my other side is appearing or not. My lord, the issue is single teacher, single subject teacher. My lord, if you lordship
Not
make
today.
it not today, but tomorrow. Lordship, I am obliged. Obliged.
Lordship, in item number 17, I am for the state lordship.
17 minutes, then 17 minutes. 17, Mr. Banerjee, 17 is there. But this issue is a single teacher. It has been rejected, only round up, but not single teacher.
17.
Key. 17 not today, already not today.
Lordship, is it 18, Lordship? Lordship, am I audible to you, Lordship?
18.
18, Lordship. Lordship, I am appearing for the petitioner.
I am petitioner. I am led by senior Devbrat. He is
Who
on
is the other side?
Lordship, may I humbly pray one thing before your Lordship? Lordship, one thing. Only on Friday, Lordship can fix it. Friday, this is an item number 20, so that I can physically appear before your Lordship.
Friday.
Item 19.
19 Millard, I beg to appear Millard for the petitioner.
No, appear for the status.
Millard, here Millard, I'll just give a Millard brief facts of the case. Millard, prior to Millard going to the facts, Millard would kindly take the last order once. Millard, that would be Millard, we have to take a leave probably Millard to correct the cause title. Milord, if Milord kindly sees the last order of Justice Aniruddha Roy once. Milord, initially, Milord, the matter was filed, Milord, under the trade name of the entity. Milord, subsequently, the trade name was used in the cause title of the petitioner. Now, Milord, it has to be, Milord, rectified, Milord, by adding the company under whom the, Milord, the entity operates. Milord,
Company.
yes, Milord, that leave may be, Milord, granted to us in course of the day, Milord, we will, Milord, amend the cause title to that effect.
Yes.
Now, Milord, to that extent, Milord, we were also called upon by this honorable court to prefer a supplementary affidavit, Milord, disclosing the relation between the company and the petitioner who is now before your lordship. Milord, the trade name which has been used. Milord, we have preferred this supplementary affidavit, Milord, incorporating, Milord, the.
No, sir. In this way, the petition cannot be amended like this. You'll have to file a fresh writ petition. This is not maintainable. You cannot change the petition as identity like this.
No, Milord, kindly, Milord, appreciate this. Milord, it was a company which operates the business under different trade names.
I understand, but
Yes.
who has affirmed this? This can, who is the second writ petitioner?
Milord, the second petitioner, Milord, he is the one of the principal officers of the company.
General manager.
General manager. So, Milord, even otherwise, Milord, it would be probably, Milord, subject to
It's a
correction
limited
would be
company, private
maintained.
limited company.
Yes, Milord.
It's a private limited company.
It's a private limited company.
No, then this way not maintainable, sir.
Milord, and Milord, it has been affirmed by the petitioner number 2 himself, on behalf of himself and the petitioner number 1.
The petitioner number 1 is non-existent.
Petitioner number 1, Milord, has been inadvertently, incorrectly, Milord,
It's not
implemented,
an
Milord.
inadvertent mistake.
Now, Milord, if Milord, only the liberty is granted, Milord, to amend the cause title by incorporating
Can't
the
be entire affidavit
company.
changes. Entire affidavit changes. See, the entire affidavit will change the affidavit portion.
Milord, it has been inadvertently written as a director of petitioner number 1.
These are the mistakes for which they will have to suffer.
Milord, that's, Milord,
Cannot be rectified. This cannot be done by amendment. Entity entirely cannot be changed by amendment.
yes. Milord, in the writ petition, he has stated that he is
General
doing it in
manager.
the capacity as a director of the petitioner number 1, but petitioner number 1 is not a company.
No, then you need to take out an application then.
Milord,
In this way, verbally, this cannot be possible.
Milord, we have affirmed the supplementary affidavit in terms of, Milord, the earlier order passed by this honorable court.
Where
Milord,
is the affidavit of competency? Have you filed?
Milord, the affidavit of competence, Milord. আচ্ছা, file করেছো? কোথায়? Copy রাখুন। Let's probably, Milord, annex to the your lordship's
that?
file.
Where is that?
Milord, আছে ওখানে? Competence? Copy রাখুন এখানে, এখানে আছে?
Nothing, everything goes, Sir, your Vokalatama, from Vokalatama, everything goes. The Vokalatama has been executed in the name of the company, trade name.
So let allow the liberty, Milord, to file afresh.
Not maintainable, not maintainable.
Milord, file afresh with
Yes,
correct
yes,
particulars.
It appears that petitioner number 2 is a director and is one of the directors and general manager of a company called.
Milord, the company is, Milord, called the Milord, company the নাম কি জানো? কোথায় নাম?
Jalpaiguri Hoteliers and Trading Private Limited.
Milord, Jalpaiguri Hoteliers and Trading Private Limited.
Jalpaiguri Hoteliers and Trading Private Limited. The state company
Certificate of
has
incorporation
not
to
been
own company.
included as the petitioner in this case. And instead, the writ petition has been filed in the name of the trade name of the company.
Yes.
In the trade name of the company. Has been filed in the trade name of the company as petitioner number 1. The writ petition is not maintainable in its present form. Accordingly, WP number such and such is dismissed with the liberty upon the petitioner number 2 to file afresh. Granting liberty upon the petition number 2 to file afresh.
Grateful.
Dismissed. Dismiss for default.
Lordship, in this matter, I am appearing for the petitioner. Lordship, I am humbly praying before your Lordship. Lordship may adjourn the matter and on Friday and thereafter, Lordship may kindly fix up the matter as per your Lordship's convenient so that I can appear physically.
Yes, call the next matter.
Deeply obliged, Lordship.
বাবার এই এসিটাকে একটু বন্ধ করলাম না বাবা।
Responded National Highways Lordship.
You are the petitioner. Petitioner.
না না এটা representation consideration করতে যাও না by the dispute.
He decides the lawsuit and certain portion of that land which has been made the special land commission of this lawsuit, they have acquired the fee schedule of that. Thereafter, the notice was been sent to me. Thereafter, some other persons of these parties are also claiming the compensation amount. There was dispute between the other party and with the petitioner, and the dispute was been heard by the land acquisition officer. Two successive hearings was been made. We know prior order was being passed. They after disbursed the said amount to the private respondent. Thereafter, the notice written representation was been made to the respondent number 3, special land acquisition officer, that if the dispute has been occurred between both the parties, it shall be taken to the principal civil court of origin as per section 3H of code. They have also not complied section 3, which says that determination after determination of the dispute the amount shall.
Who is for the other side? File your report. File your report. Have you filed it?
No, you are not.
You are for whom?
We are for the state response.
And you are
National Highways Lordship.
National Highway Authorities. Awesome. The respondents shall file their affidavits in the form of a report. The respondents shall file their reports in the form of affidavit. Within a period of 2 weeks. Place this matter after 2 weeks under the same. Again, the respondent. We lend a legal in response to the allegation present in court. Allegations made in the allegation. Under the same hearing. Under the hearing.
Lordship, crime.
2 weeks, file it by 2 weeks. Passed over. 20 to pass over.
23.
I'm for this stage.
Service about private respondent matter is not completed. I'm sent by the post.
Friday, come on Friday. Friday. Friday.
I am for the opposite party. Mr. Andari Millard used to appear Millard for the petitioner.
First over. First one.
Millard fixes up a date in the next week, probably Millard. Mr. Andari comes from Calcutta. I haven't seen him today.
Thursday. Thursday or Friday, Budvar.
Well, Tuesday then, Millard, Tuesday next week.
Excuse me.
Yes.
The 2019 civil division, what is this? What is the matter?
Millard, it's Millard, tenancy dispute, Millard, subsequently the original tenant passed away, Millard, 7-2 application was not adjudicated. Millard, kindly, Millard, tomorrow, Millard, then kindly.
Wait, tomorrow, not today, not tomorrow.
Not, just not.
ये अपेयर को नहीं करना प्लीज नहीं तो की करो not today, simple not.
My lord, 25, my lord, I'm for the petitioner, my lord. My junior is over there, my lord. My lord, this relates to section 24, my lord. A transfer of a matrimonial suit, my lord. My lord.
Other side.
No.
Give a notice upon the other side, we'll take it up tomorrow, not today.
My lord, then kindly, my lord, next Thursday, my lord, or Wednesday, my lord.
Wednesday, day after tomorrow.
I'm obliged, my lord. Wednesday. Next Wednesday.
Next week. Next to
Wednesday. Obliged, my lord. Obliged.
Next week. Next week.
Lordship, in item number 26, I am praying for a note today.
You are for the petitioner.
Lordship,
What is the matter about?
Lordship, I am not briefed in this matter.
Not today, come tomorrow, otherwise we'll dismiss.
Deeply
You know.
I'm for the petitioning, your lordship.
Millard, 26, Millard, I am for the opposite parties, Millard, on the last.
26 already took time.
26, you are there.
Yes, Millard, for the opposite parties, Millard, there's a long pending revision, Millard, on the last occasion, I sought for a copy, Millard, it was
26
not
actually
served.
your key time child over there. You are for the opposite party. Why didn't you respond?
Millard, I'm sorry, Millard.
We have fixed it.
Pass over, Millard, it's not passed over.
ওই তো
Tomorrow, 26 tomorrow.
আচ্ছা তো।
Yes.
Lordship, I am for the petitioner, lordship. This is a case which I filed by Mr. Under section 10B of Indian Telegraph Act. My innocuous prayer before your lordship.
Which is your other side?
Actually, so far my knowledge goes, Power Grid and all the respondents appeared through Mr. Sudipto Kanto Bhumi. So far my knowledge goes, but so far the private respondents are concerned, they did not appear.
Give them notice. Give them notice. We'll take it up on next. When should I take it up? Next Monday.
Next
Monday.
Monday. Or rather next circuit bench.
Next
circuit. Actually, I will in the course of the day I will send the notice.
No, Monday, not next Sunday.
Monday. Lordship. Monday की छुट्टी है ना? Don't maybe fix on Tuesday your lordship.
Monday छुट्टी है, Tuesday.
Gratefully, your lordship.
Lordship, 27 item.
Praying for a day's accommodation, your lordship. I'm not the advocate on record. I have only been requested some personal difficulties, your lordship.
Who is for the petitioner?
Ronit Kumar Jha, the advocate.
Not today.
Not to
Not today.
refuse.
29, Milord, I beg to appear, Milord, for the petitioner. Milord, earlier,
Who is the
Milord,
other side?
Milord, the other side is Milord unrepresented. Milord,
Have you served? What is the
Milord, my affidavit of service, Milord, is not ready. Milord, there was a stay of Milord the proceeding under the Senior Citizens Act. Milord, the order being absolutely perverse. Service one, yeah? Everyone service card.
Yes, who is your other side?
Milord, other side, Milord, is not. Milord, I will file my affidavit of service, Milord, kindly text it up on Tuesday. And Milord, my stay be Milord extended. I am within time.
But service should be shown.
Milord,
The
Tuesday.
other
then.
direction, unless you serve how.
Milord, Tuesday, Milord, Tuesday. Yes.
Tuesday, give them a notice.
Yes, sir.
Otherwise,
Milord, I will Milord serve afresh
You
and
have a-
file my affidavit of service.
Appears to be an order without any jurisdiction, but serve notice upon other side. If they
Yes,
appear,
yes.
only then it can be.
Yes,
shown.
yes.
Have you served the copy?
It has been served, Milord. My affidavit of
manager
service is
notice.
not, Milord, I'll do.
Yes. Tuesday.
Item 30 and 31 service not yet been completed. The third part not affected. Kindly fix the matter on Monday.
Monday, Tuesday, next Tuesday.
ওটা বলো কোনটা?
Lordship, in this case,
You are for whom?
for the petitioner, my lord.
What is the matter about?
My lord, an injunction was granted against the petitioner by the trial ex parte. Thereafter, the petitioner appeared and filed WO, WS, everything is ready. The trial court fixed 12/9. Injunction was granted in the month of March, and it was fixed on 12/9 for hearing injunction. Nothing took place. Now it has gone to 2024, this January.
Show me the order sheets.
Lordship, we have to file the new order sheet. So later,
Show me the order sheet Tuesday.
Lordship, on Monday,
Monday, I am not coming. I do come.
Tuesday,
Will you come?
Tuesday, my lord. Oh, Monday is closed. So Monday, Tuesday.
Tuesday.
Get my lord. It doesn't. Lordship, also we have to complete service. A mandatory injunction petition filed by the petitioner was refused by the court.
Refused.
151.
Refused, then revision doesn't lie, appeal lie.
151.
Even 151, so.
Petition under 151 was refused.
What was the prayer, nature of prayer?
My lord, actually, it was a prayer for granting mandatory injunction, status quo ante.
Then will appeal lie or revision will
My
lie?
lord, under 151 is not appealable, my lord.
Suppose I file an injunction application giving caption under 151. In
No,
some
my lord.
cases, the injunction
If
application.
the prayer is for mandatory, then it is not 13, order 39.
If
The
the,
prayer is for mandatory, it will not be under order 39.
where you will see on the next day, object service next Tuesday.
Tuesday, my lord. Let me.
First of all. Appealing for the
33, Milord, is appearing for the first time, Milord. I am for the petitioner.
33.
Yes, Milord. 33.
Yes.
Milord, Milord, I am Milord, on behalf of the plaintiffs, Milord, a suit was preferred by me. Milord, principally, Milord, praying for a decree for permanent injunction. Milord, on the basis of my prayer and Milord, having considered the urgency, an ad interim order was passed. That was continued, extended from time to time on the basis of applications made on my behalf on several occasions. Now, Milord, on a particular date, Milord, in spite of preferring an application for extension, Milord, that was not extended. Subsequently, Milord, other applications came in. I consistently, Milord, continued making applications, Milord, for extension of the interim order. My interim order has not been extended. Milord, I am aggrieved by the last order.
Appealable order.
Milord,
Appealable order, not revisable.
not on merits, Milord. It was not done on merits. Had it been, Milord, not extended on merits, Milord, it would have been probably, Milord, an appealable order.
Everything is, every order is judicial order is first on merit, Mr. Vikramaditya.
No, Milord, kindly text, Milord, Milord, the last order, Milord, how it has happened. Milord, probably, Milord, I will be able to persuade your lordship that it is probably, Milord, subject to jurisdiction under 227. Milord, kindly text page 46 once.
Forty-six.
46, yes, Milord. Annexure F to my application, Milord, 9th December 2022.
Yes.
Yes, Milord, today is fixed for hearing of petition under 1 Rule 10 of the CPC and filing of WS by the defendants. Plaintiffs files Hajira through learned advocate. Defendant number 2 press for files a time petition. Plaintiff not presses the petition under order 1 Rule 10 CPC. Hard peruse considered petition under so and so is hereby rejected to so and so date for filing of WS by defendant number 2 and 6. Now, Milord, kindly turns over to the next page. Page 47. Milord, kindly see the, Milord, this is my application seeking, Milord, extension of the ad interim order.
Yes.
And it was affirmed on 9th day of December. Milord, which shows that the application was on record on that day. It was placed before the learned court. Milord, despite that, Milord, this was not considered. And Milord, in a mechanical manner, the order has been passed, Milord, without extending my ad interim order. Now, Milord, as has fallen from your lordship, Milord, had it been rejected, vacated, modified on merits, on hearing of the parties, Milord, definitely it would have been an appealable order.
No, sir, I give you time to come up with the judgments. It's
right.
It amounts to refusal of an interim extension of order.
Due to inadvertence, if it has not been done, the question will.
No question of inadvertence. No question of inadvertence.
My application has not been dealt with also. So, Milord, it has to be, Milord, on the face of records, Milord, it is, Milord, probably, Milord, it has been ignored or, Milord, inadvertently not taken into account by the learned court below. So, Milord, I am only.
No order has been passed on this.
Nothing. Milord, I have shown the order.
Attention before the court that my order needs to.
Milord, we have done that. That has also not been, Milord, considered. That is, Milord, my impugned order. Milord, we have subsequently preferred an application under 151 also. For
What happened to that?
Milord, that has nothing has happened. Milord, can
No order is passed.
No order is passed. 10th July 2023, Milord, the impugned order, the certified copy of which is on record.
Where is that?
Milord, the certified copy, the order. Milord, 10th July 2023, the impugned order.
Yes.
Milord takes the order. Today is fixed for hearing of petition under section 151 CPC. Plaintiff files Hajira, defendant number 1 to 6 file Hajira. Plaintiff files a petition for extension of the ad interim order of injunction.
Yes.
Now, Milord sees the entire order subsequently. This has not even been taken care of by the Honorable learned court below.
What has been observed? Read it first.
Nothing. Milord kindly sees the order. Milord, the court completely went to a different trajectory. Defendant filed 2 applications under order 6 rule 18 read with section 151 CPC and another petition under 151 CPC praying for dismissal of the suit. Copies are sub, let it be kept with the record. Learned advocate so and so files a vokalatnama on behalf of defendant number 1 along with a petition that the defendant number 1 after receiving summons is appearing for the first time in this suit, and after appearing it has come to his knowledge that someone has already appeared as defendant number 1 without his knowledge, signature, permission and authorization, that the signature in previously filed vokalatnama written statement so and so necessary orders be passed along with these 2 applications praying for time to file WSWO is also filed on behalf of the defendant number one. Record reveals that learned advocate Sri so and so have already filed Vokalatnama on behalf of defendant number one today. Today, learned advocate so and so is appearing on behalf of the defendant number one with contention that the previous appearance of defendant number one is forged. Therefore, prior proceeding further with the suit, the court find it prudent to direct learned advocate Sri Ravi Bhushan Thakuri, Sri Shubham Tamang and learned advocate Banusri Bhattacharya to produce in person their client along with original identity and address proof on the next day. Considering the peculiar situation, hearing of petition is adjourned to 3rd October 2023 for production of respective clients in person by advocate so and so along with original identity and address proof. So what was the fate of my application? By way of vacating of my injunction, I have suffered prejudice, there is no doubt about it. The court has granted me the injunction. And without hearing on basis, merely by a mistake that has been perpetuated on several dates subsequently.
This amounts to diffuse the interim order, the extension.
So that has to be recorded in the order, Miller, subject to correction.
No. If find out judgment, I'll give you an opportunity, but otherwise this is an applicable order.
Right, Miller, does Miller allow me to come back on Tuesday?
Tuesday. Come up with the authorities, yes.
Yes, grateful, Miller. If Miller kindly records an order, because Miller 3rd of October my date is fixed before the lower court. So Miller, since it is pending, at least Miller on Tuesday, Miller we can pray for an adjournment.
3rd of October means next Tuesday.
Yes.
3rd of?
3rd October. Miller, the 3rd October is the date fixed before the learned court.
Today we are on?
Miller, today we are on 27, 26th. 3rd of October.
29. You can do it at
29 Miller, I have some personal difficulty. Miller, that's why I was praying for tomorrow. That'd be okay.
Find out any judgment on the maintainability.
Miller, preferably on Tuesday, Miller.
Very well, Tuesday.
Can you adjourn till?
Not necessarily. We'll see on Tuesday.
Grateful. Again, 34, 38.
There are two matters, Lordship, 34 and 35, Lordship. 35, we have from the side of the petitioner, we have for the enhancement of our Lordship, we have prepared this appeal, Lordship. And challenging that order, actually, from the side of the insurance company, another appeal has been filed. So both the appeals are together, Lordship. Both of them required to be heard together and disposed of, Lordship.
Yes.
So from the side of the petitioner, Lordship, the grounds are, Lordship, the deceased was a central government and employee, Lordship. So at the time of passing our Lordship, learned tribunal has not considered the actual salary of the deceased, Lordship. They have deducted, Lordship, which is not permissible as per law, Lordship, in view of the judgment of the Apex Court, Lordship, in the case of National Insurance Company Limited versus Indira Srivastava, Lordship. So they have deducted, Lordship, 7,675 rupees, Lordship, from the total salary, Lordship, under the head of house rent allowance, risk allowances, RM. So total 7,675 rupees deducted from the original salary, Lordship. Original salary was 32,265, but the salary which has been taken into consideration, Lordship, 24,590, Lordship. So which is not permissible, Lordship. And another point is, Lordship, only 6% interest has been granted, Lordship. So
what is the percent?
6% only. So we have prayed for 9%, Lordship.
6%.
That's 9%, Lordship. This is the all about that.
And what is your appeal about?
So for interest, 6% is generally awarded. And so for the income is that is admitted position. And so for our.
What is your ground of appeal?
Lordship. So for our ground is appeal is that the first ground is that this is a case of implantation.
Yes.
Implantation.
Vehicle against whom the claim has been lost. Maruti Swift that has never been involved. Lordship kindly takes up page number 43 of our paper book. Lordship.
Page now 5 to 9.
43.
43 Lordship.
Yes,
The FIR.
yes.
From the FIR, it will reveal that it is in Bengali. যে আমার ভাই অমুক অমুক সিআরপি জওয়ান ছিল এবছর এত পুজোর আগে ছুটিতে বাড়িতে এসেছিল গত 21 অক্টোবর 2016 আমার ভাই পালসার মোটরসাইকেল যান রেজিস্ট্রেশন উক্ত গাড়ি নিয়ে ব্যক্তিগত কাজে জলপাইগুড়ি মেইন রাস্তা দিয়ে ফেরার সময় আনুমানিক রাত 10:30 নাগাদ পুকুরডাঙ্গা বাজারের কাছাকাছি একটি গাছের সঙ্গে ধাক্কা লেগে সো there is no whisper of the offending alleged vehicle against whom they have lodged the claim. It is the clear statement in the FIR upon which they are relying exhibit 1 that the victim was traveling by motorcycle and while returning home the vehicle met with that accident while he lost control and dashed a roadside tree. And from the claim petition it will appear at page 1, Lordship.
Lordship, may I submit, Lordship?
This one is evidence.
Lordship.
In evidence, the vehicle number must have been from.
Lordship,
It keeps supplementing.
this is the first FIR, Lordship, which is indicating Lordship. Subsequently, when GD was lost, Lordship, and on the basis of the GD has been coupled with the FIR, Lordship, and subsequently investigation began. And after the completion of the investigation, it was found that actually due to the offending vehicle, the accident occurred. Actually, charge sheet has been submitted against the driver of the offending vehicle. Moreover, the plea which is taken by the insurance company right now, Lordship, kindly see the page number 44 of our page paper book, Lordship. No, sorry, 5 to 9, Lordship. 5 to 9, Lordship. This is the written statement filed by the insurance company before the court below. There is no whisper to that extent that this vehicle was implanted.
Where is that? Where is that?
Paper book, on my paper book, 2 paper books have been filed, Lordship.
Hamida Khatun, which page?
Hamida Khatun versus
Which page?
Page number 5 to 9, Lordship.
Yes, in the written statement, fire raised this point that the vehicle was not involved.
No whispering, Lordship. The first time they are raising this issue here.
Or before the tribunal will have raised the point.
Even driver.
It is depends there that they have to prove understatement that the vehicle was involved in the accident.
Must be
Why
defense.
have you said?
Not.
No OPW was examined. No OPW. Even the driver was not called for. Even the owner was not called for. No. Yes, we have accordingly proved the case.
For me, that why have you taken the point?
Para 2 of our W is at page 5, Lordship.
Okay.
All material allegations are false. It's not maintainable against this.
General.
Because it is proved by
It's like a copy paste, Lordship. And in view of the judgment of the Honorable Supreme Court passed in the year 2023 in the case of Ashalata, Lordship, it has been categorically stated by the Honorable Apex Court that if there is any plea from the side of the insurance company regarding the implantation, so driver must be called, must be examined by.
Where is the judgment?
I'm just.
Bring the judgment.
I'll file the judgment, Lordship. Apart from this, there is a judgment of our Honorable Court, Lordship, in the case of Mita Samanta and Putniya Bai, Lordship. It's a famous judgment, Lordship. Mita Samanta. I'm
Very good.
Huh? Lordship.
Now you always a very good MSSA lawyer.
Lordship.
Lordship, so far our appeal is concerned, the accident took place on 21st when this complaint has lost the FIR against the vehicle.
Show me even before the learned tribunal below that point you raised. That this is not a.
So our specific this vehicle was.
No defense is there.
They have to prove their own case. We have denied the.
We have filed the charge sheet. We have filed the. We have actually produced the eyewitness.
Where is the investigation report?
Investigation report, Lordship, in the charge sheet. In the page number, Lordship. There's 48 to 50, Lordship.
Of your paper book?
40, yes, my paper book, Lordship. 48 to 50.
The chart sheet also, it is
But your paper book only consists of 48 pages.
41 to
41 to 43, 41 to 43, Lordship.
page number 50 of my.
41 to 40.
Where is the vehicle number is mentioned?
Yes, 41 to 43.
Where they have mentioned the vehicle number?
Yes,
The
Lordship.
vehicle?
Page number 43, Lordship.
Third para.
Place it. Vehicle number is not mentioned.
Third paragraph. During investigation, some notice after receiving particulars of offending vehicle bearing number WB 74 H45.
First paragraph.
Third paragraph.
Yes. During investigation on complaint, loss taken such and such.
Serve notice after receipt particulars of offending vehicle bearing such number such and such from RTO office Jalpaiguri.
Yes, then.
According to
During-
the register owner C Sanjeev Roy of such and such under section 91 of
What kind of paper book? This you'll have to type it out. All paper books are typed. You have just simply.
This is a certified copy, Lordship.
Maybe certificate.
What's your certificate? Certificate copy.
You should type it out.
Jalpaiguri to register on Lordship, next by Lordship.
During investigation. Serve notice
Yes, Lordship.
after.
College to SCD, dead body
Offending
challan, Surutal, huh? Lordship,
Only
it is more prominent, Lordship. This is one, Lordship. This is original certificate copy.
Chart sheet is also not complete. Complete না।
ওখানে কমপ্লিট আছে
না, এখানে correct chart sheet নেই।
অরিজিনাল আছে প্রথম পাতাতে আছে না সেকেন্ড ওটাও তো আছে এই এই ওখানেও আছে দেখি তো ওখানে কোথায় আছে শ্যামল দাসটা কোথায় না না পেছনে কোথায় নোটেড ইন কলাম নাম্বার 1 লেখাই আছে 11
Where is the chief? Where is the cross? Where have you given a
Yes, Chief,
suggestion?
Lordship.
That it's a the vehicle, the offending vehicle.
Lordship 14 to 18, Lordship.
Yes,
Petitioner affidavit chief 10 to 14,
14 of
14 of paper book, of my paper book, Lordship. And deposition of PW to 15 to 18, Lordship. You start from page number 13, Lordship.
no, this is not the way to prepare paper book like this.
Plus,
I will not permit.
I use this paper.
You type it out. What is the direction for formal paper book or informal paper book? Where is the direction for paper book? Dekhi shona. Paper book, no, this is not informal, this is not paper, this is not the way to prepare a paper book.
So, Lordship, I have to type it out, Lordship.
Yes,
Okay, Lordship. So, Lordship, kindly keep
you
it.
need to type it out in that thing, file the copies under the department, and the department will serve all this.
Department already filed.
Everything is being done so formally, informally.
File before the department, Lordship.
Not like this, this is not the way to prepare a paper.
Okay, Lordship, Lordship, I will type it out, Lordship. Lordship, kindly keep it, give it 2 days accommodation, Lordship. I'll prepare it. I have to type it out.
Ke porbe chief paper? File paper books.
লোয়ার কোড কি আছে লেখা আছে লোয়ার কোডে কোডে এলসিআর আছে লেখা আছে তো আমি দেখাব না এলসিআর আছে না হ্যালো এলসিআর আছে এলসিআর আছে ওকে ওকে
Lower court records have come.
No, yes, Lordship, yours is there, Lordship. Lower court report is there, Lordship.
Where is the chief? Where is the cross?
Yes.
Preparation of paper book is a formal thing you need to learn.
Yes. Yes, Lordship.
Not so informal, everything is being done.
Right from the next time, Lordship, I will do it, Lordship.
This is the first appeal, the way the first appeal paper books are prepared, in the same way you'll have to prepare the paper. The lower court report will come, then there'll be.
Lower court record have already come, Lordship.
Paper book.
Okay.
এখানে আছে পেপার বুক সেকশন আছে এখানে
The civil section is also, they are maintaining actually. No separate. Civil section is taking care of paper books, Lordship.
Not civil section, first appeal, there is a first appeal বলে আলাদা কিছু করা আছে এখানে
First appeal আলাদা কিছু নেই No, no, no. First appeal. No, no, no.
খবর দিয়েছেন
Judgment আসছে এখনো judgment আসেনি
Yes, what I am on that whether the insurance company gave any suggestion before at the time of trial that it's a.
No, Lordship.
What is the suggestion?
Because there is no specific suggestion, Lordship. Even in the written statement, no additional written statement has been filed. No driver.
in the defense of the instrument is in para 2 and para 13 of the WS. It is
No, no, not WS, during the evidence.
in evidence, Lordship, in cost of PW1, I have never examined my full. I am not a witness to the incident. One of my son, namely Mustaq, has lost the affair. Not a fact that the accident took place on the daytime manner. Not a fact that the instant vehicle.
Petitioner is the mother. Petitioner has not seen the incident.
Wait.
Not a fact that the instant vehicle has been planted for the purpose of completion. Not a fact. My claim is excellent. So this point has been taken in cross-examination of PW1 and also cross of PW2.
Or read it, not a fact that?
Not a fact that the instant vehicle has been planted only for the purpose of compensation. And in cross of PW2.
Planted only for the purpose of?
Compensation for getting and the eyewitness, he was PW2. I was never examined by police. The distance between Bugudana Bazaar and my house is about 10 kilometers. Not a fact I am witness to the occurrence, not a fact such accident took place as stated by me, not a fact the deceased himself dashed the tree and got injured. Not a fact the vehicle Maruti Swift did not dash the vehicle. It is the cross-examination of eyewitness. And so far the income portion is concerned, no witness has been called for to prove the income of the receipt. That is also vital for the purpose of computation of the compensation. No witness has come forth to depose in this case to prove the income, rather salary of the victim.
He was a CRPF employee, Lordship.
In any case,
All the documents, actually, he was posted in Jammu and Kashmir, so all the documents have been filed.
proved by any cogent evidence, the income of the
Even
Why the evidence never improvements was? Who, how the evidence was?
it was marked. It was marked.
no rebuttal evidence has come with your Lordship.
বলছি আপনাদের এখানে যে এমএসসিসি গুলো ফাইল হচ্ছে বা ফার্স্ট অ্যাপিল ফাইল হচ্ছে পেপার বুক তৈরি হচ্ছে ডিপার্টমেন্টে সিভিলে পেপার বুকে হয়নি ঠিক অনেক জানুন জেনে আমাকে বলুন পেপার বুকের কি কাজ হচ্ছে কিনা কি প্রসিডিউরে কাজ করছে কটা পেপার বুক ফাইল হচ্ছে কটা কম্পেয়ার করেছে কোন কি কাজ হচ্ছে না
Lordship, with regard to salary, Lordship, the point which is raising, Lordship.
How the salary was proved?
Actually, Lordship, kindly see.
Salary certificate was given.
Yes. Salary certificate was exhibited without objection.
No.
They have not raised in objection because the government, actually, the government certificate, Lordship, he was posted. He was, let me complete. He was posted in Jammu and Kashmir, Lordship.
What is the list of exhibits? Exhibits
Exhibit 9.
in the paper book?
Exhibit, page 47, exhibit of my paper book, Lordship. Page number 47.
It was exhibit what?
Exhibit 9. Exhibit 9.
No, wait, look as well. Look. Who proved this? Who proved this?
No witness.
No witness has turned up, Lordship. We have produced the documents, original documents, Lordship. Even at that time, they have not raised any objection, Lordship.
No.
That is
what kind of
exhibited,
objection? Come on,
Lordship.
you exhibited document, you have been proved.
Even-
I don't understand what's really going on. Who has proved it? How it has been marked?
It hasn't marked because, Lordship, actually, we have candidly submitted before the learned tribunal, Lordship. Actually, the CRP, he was a CRPF employee, Lordship, and he was posted in Jammu and Kashmir, Lordship. So it was really the hardship on the part of the petitioner to bring the witness or the competent person from the Jammu and Kashmir. So it accordingly, learned tribunal, after hearing us, Lordship, exhibited this document. Even
How
after-
it has been exhibited? I don't know how the document can be exhibited like this.
It's a government
Without being
document. It's a government document, Lordship. It's a public document, Lordship.
Who told you it's a public document?
Salary, actually, from the side of the central government, GC CRPF battalion, Bantala, Jammu, Their accounts officer only lordship forwarded the document.
It doesn't happen like that. It doesn't really happen.
Normally what we do, lordship, normally we summon the competent person where actually the employee was working at the relevant time of accident.
It's no question of abnormal, normal. A document needs to be proved by the executive.
Absolutely, lordship. That is the procedure,
No,
lordship.
I won't allow this.
That is Jammu and Kashmir, so actually, lordship, is not possible, lordship. That is why.
Not possible, you don't.
And we have already filed the original document in the lower court, lordship. That document has been exhibited. That the document and the ID card in every supporting documents.
Good.
We have filed.
Document ID card.
No, not exhibited, true only.
Exhibited. You see, in the lower court record, it is lying there, lordship.
This has not been proved, sir. This way the tribunal cannot act like this.
Even not the slightest evidence come from the side of the insurance
Need not.
company.
Need
That is the rebuttal evidence
Need
that
not.
actually he was not working there. He
Need
was
not.
not a CRPF constable.
Need
He
not.
was not working there. He was not receiving the salary. No such evidence has come before the learned tribunal, lordship. Even they have at the time of exhibiting, marking this document, actually they have not, she was all alone present there.
No, I was.
I met an insurance company was all alone present there. Because even they have investigated from their side. Because after every case, registering their case, actually what they do normally they
The
appoint
way you need to learn how to file paper book, the
Lordship.
same way you need to know how to prove a document for the trial.
lordship. I will do that. I will take care of the lordship. Lordship, I will take care of that. But you kindly appreciate this document, lordship. Lordship, original document is lying with the record.
No, sir, without the document being proved, I won't allow the order ever to be passed on this. No one proves the document, salary certificate, the basic foundation. No one even know.
Lordship. Actually, we have just placed our submission before the learned tribunal, lordship. Yeah, the situation actually was working in.
Show me that lower court record, how it has been exhibited.
Lordship. Please give me the lower court record, please.
Work on the salary certificate work on. Lower court record. It is.
Original certificate. Original certificate. এটাই আছে শুধু। হ্যাঁ? Neither-
No, this has not been exhibit 9.
Exhibit 9, lordship.
How it has gone into evidence without being proved?
Lordship, kindly see. that
You can
They
accept
are,
this,
they
there
are,
is no
they are,
letter
they were,
from
now
the-
they are,
prove that it-
now they are saying after lordship indicating this lordship, when actually it was marked lordship, it has been marked. There was no objection from the side of the, because they have investigated. Yes, he was working there. Even it is very much within their knowledge that this person was working under the CRPF and he was posted in Jammu and Kashmir, lordship.
No, unless.
Because lordship,
Any objection at this point of-
lordship, I have one Inocos prayer, lordship. Kindly fix it in the next circuit, lordship. By this time, lordship, give me the opportunity so that I can collect some documents or if you can make the RTO or something like that, lordship.
What are you? It doesn't happen like that.
No. Lordship, actually it is pending since 2016, lordship. They have not get even this single price, lordship. Great hardship, lordship, this petitioner is lordship.
But hardship, that there is a procedure.
No,
sir.
procedure, lordship. The learned tribunal, lordship, accepted this. That's why,
No.
lordship, we have not given any further endeavor
We
to
don't
bring
know.
the
I mean,
witness
it-
from the Jammu and Kashmir, lordship.
It appears that the award of the tribunal below is based on a salary certificate issued by the accounts officer, GC, CRPF, Mantalab within bracket Jumbo, beta capital, therefore Mantalab within bracket Jumbo. Next madam. It is quite surprising to note that the said salary certificate has been marked as exhibit 9 without the same being proved by any of the witnesses. Next panel. By any of the witnesses. Any of the witnesses. Next panel. Learned advocate appearing for the appellant 6 times. Leaves this matter. Learned advocate appearing for the appellant to do touch appellant in. What is your appeal number?
Appeal number 38 by 22.
By 38 by 22 6 times. Leaves this matter after 2 weeks under the same heading. I am granting you 2 weeks.
2 weeks.
What I pointed out the infirmities. না দুটো দিয়ে একই সাথে হচ্ছে একই সাথে ক্লাব করতে হ্যাঁ
Oh, there is or
হ্যাঁ
31 30.
Yes, analogous.
2 weeks time.
Please.
দুটো একসাথে হচ্ছে। Yes, Lordship.
Don't need it. Yes.
Lordship, I am appearing, Lordship, for the petitioner, Lordship. So in this matter,
Please for the insurance company.
Mr. Bikruvalto Kosh is appearing on behalf of the insurance company, Lordship.
Insurance company.
Lordship, there is a delay, Lordship, 361 delay, Lordship. There is one can application we have filed.
How many days delayed?
361 days delay, Lordship.
First time appearing?
First time. No. Earlier there was a direction
For what?
for serving the copy, Lordship, upon the insurance company, Lordship.
Preparation of paperwork and.
Yes, we have already. There was a direction.
There is a direction for preparation of.
Direction. Direction. All the respondents.
No, only the section.
Only section 5.
How many days delayed?
361 days, Lordship.
360 days.
361, Lordship.
Here's what you said. You want to have you filed any objection?
No.
You want to file any objection?
Come up with an objection. Let's say
Ask.
61 days.
Also,
Lordship, I have canvassed all the grounds, Lordship.
the insurance company, they are entitled to file an objection.
Yes, they are
Insurance
entitled, Lordship.
company 6 times to file affidavit in opposition to the application filed by the appellant for condonation of delay in preferring the appeal. Let such affidavit in opposition be filed within
Next week,
2
Lordship.
weeks from date.
2 weeks.
Reply that TFNE may be filed 1 week thereafter. Is this matter after 3 weeks under the same heading?
Next.
And we are
Lordship.
in this field due to some of the insurance companies.
No, it's a-
Also in the meantime.
No. Now there are 2 judgments which are holding in the field.
Lordship, Product and.
Yes.
Sola Burma.
But the most important part is the procedural part.
Yes.
Because these are as first appeal, preparation of paper book, service of notice.
Yes.
All these are departmental works. Now we'll ensure that these are done formally because this circuit bench has been running for more than
Yes.
5 years, I believe. By
2 years
5
you are not in operation.
But 5 years, you should learn all the procedures.
Yes, Lordship. Lordship. We are trying to learn
Enough
the things,
of
Lordship.
indulgence have been given. Now is the time we'll do everything.
Lordship, just for 2 years COVID period, Lordship, it was not in
You do
operation.
1 or 2 matters, then we'll learn what to do.
Yes, Lordship.
Work code records in Calcutta, we used to just hand over.
Lordship, we are
Done by competent persons. Here below there is
we are
no-
trying to cope up with each.
We have become informal to facilitate justice.
And we're every day we are learning something.
It is also necessary to learn all the process also.
That's right.
Yes,
Next one, go to the next. I'm praying for not today, Lordship.
not today.
Next one. Lordship, I'm appearing, Lordship.
Yes.
I'm for the petitioner, Lordship.
Yes, what is on?
Affidavit of service to them. Affidavit of service, Lordship. You are appealing?
Lordship, they have received it. Notice.
We have already served the copy, Lordship,
I have
and
not
I hope
received
that
the-
he has already got the telephoning instruction
What do you want?
tomorrow.
No, we are, I'm not.
The next
received
week.
the-
Lordship, keep it on my.
Next time.
What is the point?
The point is very simple, Lordship. Point is very simple, Lordship. Future prospect, 20% has been granted instead of 40%, Lordship. And multiplier should be 15, and it has been applied 14, and no interest has been awarded, Lordship. So as far as the income tax return is concerned, Lordship, slightly different.
Give him a copy and let him take instruction.
Yes,
These are the standard things.
I have already made the suggested copy of the order, Lordship.
Give him a
Let them
suggested,
supply it memo.
give him a suggested copy.
I will
I'll
take,
give
I
you,
will
Lordship.
take instruction.
Give him a copy, you take instruction on this point.
The suggestive order, I have prepared the suggestive order, Lordship.
Let me go through the memo.
Lordship,
I go through the suggested orders.
go to the suggested
Not
order.
today, take instruction from your client.
Yes.
Future prospect,
No interest, Lordship.
multiplier and interest.
These are the main.
6% interest, that is their interest entitled to see the number of deceased person to understand what is the multiplier and what is to understand the future prospect, what is the family members.
Yes.
These are the things.
On Friday.
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 Sorry. Not today. Friday. We'll dispose it upon the next Friday.
Next item, what's the number? Lordship, the next matter, Lordship, only 3 points, Lordship. Monthly income has not.
Who is your other side? You are. Give him a suggested copy of the order.
Suggestive are already handed over, Lordship.
What do you say?
I will send it to my client for their approval.
Friday, Lordship. Grateful, Lordship.
Tuesday, Lord.
Tuesday. Very well, Tuesday.
Tuesday. Next.
Yes.
Some mistake. Affidavit of service, Lordship. Mr. Parthuvam is appearing in this matter actually. He told that he's on the way, he's coming, Lordship. Kindly pass it over, Lordship. Or keep it tomorrow, Lordship.
Tomorrow, come tomorrow. What is the point in this case?
For the enhancement, Lordship.
What are the factors?
3,300. Notional income has been considered 3,300. Future prospect 10% has not been added. No interest has been awarded. As
Who
per
is your other side? With
Mr. Parthuvam, he is coming, Lordship. He is on the way, Lordship.
give him a suggested copy of the order.
So
3,000 and what is the standard?
6,000, Lordship now. In view of the, even our coordinate page, the last time, Justice Patnaik also considered 6,000, Lordship, in view of the judgment of the Supreme Court. And even the homemaker nowadays is earning 300 per day.
Is there any judgment of Supreme Court?
Yes, Lordship. In the year
Bring the
2008.
judgment also, last 4 to 5 years ago, we have granted 4,500.
Yes, now it's 6,000.
6,000 reasonable now.
Yes, Lordship.
Reasonable, but bring the Supreme Court judgment. also.
Yes. I'll take the Supreme Court judgment, coordinate bench judgment, I will also
So
play.
bring your other side, give him a suggested copy and come back.
I'll keep it tomorrow, Lordship, by this.
Wait,
In the course of the day, I will serve the copy.
Tomorrow.
So I have also prepared the suggested order, Lordship. Tomorrow, it has not come, Lordship. Next. Next. Suggested order? Yes, suggested order.
Have you read that? Gone through the suggested order?
I tried to hand it over, but he said he will take it in
What are the factors?
points.
No, where is the paper book? I have not received any paper.
We have given our best endeavor to hand it over, but he said, no, I will take it in front of the.
Very good. Now it is.
So points are, Lordship, assessed rupees with 3,300, what I.
Income.
Is a similar case, Lordship. Future posted 10% has not been added, Lordship. And.
Future posted 10%.
Yes, and 171 of the motor vehicle set has not been complied. That is the interest. No interest has been awarded, Lordship. These are the three basic points, Lordship.
Go through the orders and tell me when do you have to sign.
My lord, I have just received the.
So I'm giving you time, you read all these and suggested order you also go through. Next Friday?
Next Friday.
Friday.
Suggested order, I have already handed over the suggested order. Have paper book দিয়ে দিয়েছি। Next কোনটা আছে? Lordship, the other side in this matter, item number what? Lordship, item number 42, Lordship, Mr. Pashupatinath, actually he is coming all the way from Coach Bihar, Lordship. He's about to read, Lordship.
Your other side?
Yes, my other side, Lordship. He is representing the United India Insurance Company Limited. He's all the way on the way.
What are the points in this case?
Points, one third has been deducted instead of 1/4 because number of dependents are 4. Interest and salary part slightly only P-tax will be deducted. But here in this case, it has GI also, other heads also deducted. So these are various nominal points, Lordship. And we are paying for interest 9%, but 6.5% has been granted.
So when should I keep it?
Lordship.
When should I keep it?
Pardon?
When should I keep it?
In this at 2, Lordship.
Today.
Today is not possible. Tomorrow, Lordship. He's coming from Kochia. That is the hardship, Lordship. I have no problem because I am staying here.
Tomorrow.
Okay.
Day after tomorrow.
Actually, he's a senior person. Actually, that is why I'm staying, Lordship.
No, will you be staying here or will you go back?
No, he will go back. He comes and go back.
He comes and goes. Tomorrow, then come ask him to come tomorrow.
Okay, Lordship.
This is an application. Where is your CAN application?
CAN actually is all about, Lordship, the convention of Deloitte.
Where is the application?
CAN 1, Lordship. 222 days, Lordship.
This is an application for condonation of delay. The petitioner shall serve a copy of this application upon the respondents. Is directed to serve a copy of the application upon the respondents, intimating that this application shall be taken up for hearing after 2 weeks under the same heading. The petitioner shall file an affidavit of service to that effect on the next date of the is this matter after 2 weeks under the same heading.
Grateful, Lordship.
Milords, item number 44, I am for the petition. This is a GST matter, Milords.
Who is your other side?
Milords, kindly see the last order, Milords.
No, you bring your other side.
Milords, they are not even accepting service, Milords.
Who is not available? Don't.
My lord, it's very unfortunate. Sorry, Milords.
By registered post is survey. Survey done by registered post.
My lord, kindly appreciate, Milords, that even listing is sufficient service, Milords. This matter was,
Thank you, sir.
and there was direction
The
also.
last it is not this week, sir. Whatever it is, you'll have to take service.
Milords, when are you fixing it?
Not this week.
Okay, Milords.
Second time, Durasmani. Yes, who is the petitioner? দেখে যান petitioner না থাকলে দেখুন দেখি দিন তো ফাইল গুলো পুরোনো মামলাগুলো ডিসপোজেবল করে দিতে Yes, what is the matter about?
But this relates to transfer, I believe.
Yes, what is
Well,
the
the petitioner was suspended. He's a primary, he's a school teacher. He was suspended by virtue of an office order on account of having committed offences under section 420 and 406 of the Indian Penal Code.
Yes.
And that particular order was subsequently set aside by a coordinate bench of this Honorable High Court in another writ petition. And the suspension order was also set aside. Despite the same, the petitioner was not allowed to join his service thereafter for nearly 3 years without citing any reason. That is what has been alleged in the writ petition.
Now, what is your instruction?
Well, I'm here. The answering respondent would be the district primary school council.
Who is appearing for them?
DPSC Alipurduar.
For DPSC Alipurduar, my lord, I have appeared in some of the matters, but in this matter, my lord, I have not received any instructions.
A report was called for, was directed to be filed by the DPSC also by a previous order.
But I will, my lord, take instructions and my lord, assist your lordship, my lord, but my lord, kindly takes it up on Tuesday at least. My lord, I have
Very well, next Tuesday.
Tuesday, my lord.
It is Tuesday date.
Number 4.
देखिए फाइल नहीं Who is for the respondent in this matter? When 20 is default. केवई नहीं करो हुए शिपवेट yes on the next matter
Number 7 to 10.
7 to 10, my lord, I am praying, my lord, for an adjournment till Tuesday. My lord, I have to go through the brief.
Tuesday next Tuesday you are for the petitioner
I am for the petitioner.
And for the state.
yes what do you say should I dismiss it here and now or wait for Tuesday one line order on the prayer of the learned advocate on the prayer of Mr. Vikramaditya Ghosh, learned advocate appearing for the petitioner, please this matter next Tuesday another same meeting.
13, my lord, I beg to, my lord, appear for the petitioner. Now, my lord, during the COVID period, my lord,
I beg to appear on behalf of the respondent authority.
the Provident Fund
PF
authorities.
authority. And I think the bank also in party.
Yes, what is the matter about? Proceed.
During the COVID period, the central government came up with a scheme, that is Atmanirbhar Bharat Yojana scheme. Under that scheme, the eligible establishments were entitled to the provident fund contributions to the tune of 24%, the employer share and the employee share. Now, subsequent to the scheme having been floated, certain establishments applied under the scheme to have that benefit under the scheme. Now, many of the establishments appeared upon prima facie scrutinization of their documents. They were having been found eligible, they were registered under the scheme and the benefits were duly granted. Now, this all happened in 2020-21. Subsequently, what has happened, subsequently, all of a sudden, the Provident Fund authorities came up with a notice stating that some of the documents that has been some of the documents which have been submitted by you some of the documents they say in a subsequent notice that some of the documents that you have submitted appears to be falsified. Hence, you are requested to submit these documents. They prepare a list. Pursuant to that, I prefer a reply to them. I submit all the documents which were available with us. What were the documents? The PAN card, the GST registration, the Provident Fund establishments registration, and the wage registers that I am a running establishment having employees, etc. Further documents, some of the documents were also called for regarding execution of my work. We said that since we are not a government registered contractor, we are in the unorganized sector, all of the works are not executed in terms of works contract. However, evidence of my wage register, payment of wage, everything was supplied. After that, they were supposed to conduct a hearing and pass an order as to whether the falsification has happened and what was the document, what was the details and particulars which were actually being falsified. Without doing that, all of a sudden they issue a recovery notice, which carries a conclusion that you have submitted falsified documents, but the details and particulars of fraud or falsification was not supplied in those recovery notices. This kind of recovery notices were issued against several establishments. In a bunch of writ petitions which appeared before this honorable court, two of the coordinate benches were pleased to take up those petitions. I had the opportunity to appear for the petitioners. In one bunch of writ petitions, in six cases, Justice Vivek Chaudhary was pleased to quash those notices, giving an opportunity to the Provident Fund Department that in case you feel something in particular is being falsified, you call for the documents within 8 weeks, pass a reasoned order, then take consequential steps in accordance with law. I don't know what is the fate of those cases now. I have no more instructions. This is a case where pursuant to the recovery notice, immediately thereafter, a prohibitory order has also been issued. So this goes one step ahead from the earlier cases.
What prohibitory order?
Millard, kindly cease.
I think it's only recovery notice.
Millard, page 96 of my writ petition.
Oh, 96.
Yes.
'96 of my writ petition, we would like to inform you that a hold of rupees 20 lakhs have been put in your account as directed by Assistant Provident Fund Officer Jalpaiguri. Now, I say that this prohibitory order, wherein you have put an hold into my account, thereby putting into freeze my current account, is absolutely without jurisdiction for 3 reasons. First, I say, that there are a line of judgments which say that current account of a business establishment cannot be freezed or put on hold without due process of law. Here, no due process has been complied with. Second, even assuming that there was an order, without passing an order under 7A of the 1952 Act, determining a payable amount, no recovery proceedings ought to have been initiated by the authorities. Number 2. Number 3, under the said Jojona itself, the power to recovery or do anything under the Act has not been conferred upon by the authorities. These are my 3 principal grounds. Now, since the Honorable Coordinate Bench has been pleased prima facie to set and quash all those recovery notices, here we are in a much better footing because even without a recovery notice, the account has been put on freeze. Milord, I am aggrieved by this, Milord.
What is the order of Justice Vivek Chaudhary?
Milord 96. It's annexed to the writ petition. Milord would kindly takes up that order at page 89. And Milord, subsequently, Milord, a recovery notice was slapped upon me also. Similar, Milord, a prototype recovery notice which was set aside by Justice Vivek Chaudhary, that is at page 88. Page 89, Milord, is the impugned order, Milord, not the impugned order, Milord, Justice Vivek Chaudhary's order. Milord, the relevant portion, Milord, would find at page 94, internal page 6.
Yes.
Yes, the authorities did not prefer any appeal against those
The
orders.
same order we passed.
Lordship, not the identical order of this.
Yes.
In this nature, Lordship. Practically, the scheme has come out the effect after the COVID situation to incentivize the new employment by the central government, Lordship. And the page 31 of the writ petition, that is in the object of the scheme has been stated, wherein the employee's share, 20% employer's share has been paid by the central government to accelerate the new employment. And that has been provided for those who are the enrolled with the Provident Fund Authority. They can use this scheme. Lordship, this petitioner also benefited this by this scheme, and he got here. Lordship, so prior to
Sole proprietorship.
Lordship, prior to get this scheme, he has to go for some documents has to be filed through portal, Lordship. Now, Lordship, I can kindly come to the page number 38, Lordship. In there, Lordship, 38. Modalities of implementation of a scheme. EPO shall develop software implementing this scheme and also develop a procedure. So a software has been developed, and there the whatever process is that the petitioner or the nature of the employer have uploaded their papers and got the scheme. Because of there is a emergency in nature that has not whatever they uploaded in their in the portal that has been accepted, Lordship. But there is some user because of he has to use this entire money which is been granted to him, that should be in a beneficial scheme. At that time, when after the lapse of time, it was found that whatever he submitted, the petitioner has been submitted, that also been fraud and falsification. Lordship, kindly come to the page number 87, Lordship. Kindly come to 87.
Notice is issued by whom? The PF authority.
PF authority, 87, page number 87 on 28th June 2022, he was a notice has been served. The verification of benefit available under ABRY scheme in respect of the Mrs. Bapi Electric Works being PF code number such and such, registered in continuation of the visit of undersigned on
7th June 2022, the above matter, I have been further directed to competent authority to get certified the following discrepancy. Now discrepancy is, Lordship, there is a proof of disbursement of wages. You have produced wages sheet only signed by you without any other evidence of disbursement of wages, his provisional tax, education, proof of disbursement of wages, such as a bank, etc. As per documents, you have engaged 37 numbers of workers without any contract agreement through the coverage of the EPF.
Which page are you reading?
That is the
87.
page number P6.
That is the employee notice.
That is
No, that is
they
not
have
the
been-
employee notice.
They have been asked for supply those because of their discrepancy found. They have been intimated. The petitioner has been intimated through the letter dated at 28th June 2022, and this discrepancy has been found, Lordship. And thereafter, the para number 3 establishment has been brought under the purview of this act with effect from 1st
How
November.
much money have you received?
Milord,
What was the amount you received?
20 lakhs.
20 lakhs, Milord, 20 lakhs 95,976.
Yeah,
That is Milord 24% of Milord the total wage that has been disbursed during the period.
Pure.
That is Milord at 87 at point number 3. Milord would find that the total wages shown in ECR from November 20 to April is rupees so and so. ABRY benefit level during the period is so and so. That is Milord 24% of the amount.
I don't know. After this notice was issued 28th June, what did you do?
Milord, I submitted all the documents.
Where is that submission?
No, Milord. Yes, Milord, kindly takes Milord page 45, 44 onwards. Milord, in fact, 43 onwards, Milord, are all the documents till 86.
No, where is the proof that you have submitted in response to the notice?
Yes, page 88. Milord, kindly turns to page 88.
Yes,
Milord, their recovery notice.
yes.
Milord, kindly see Milord from below, Milord, the last but one paragraph from below. Whereas the documents and other records of MS Bapi Electrical furnished by the establishment in connection with the ABRY scheme have been examined, and it is found that the establishment had availed the benefits of the scheme by providing falsified information. Now, which information is false? That there has to be a reason, order, and a finding to that extent. This is on this count alone, Milord, Justice Chaudhary was pleased to Milord quash this notice, allowing them an opportunity that whatever is there, you pass a reasoned order, say what is false.
Bona fide is required from the petitioner because of the he has to submit those documents. And if
No, all documents have been submitted.
If he is going to again submit, that is
No,
the
no.
document is
One
not-
thing is this, one thing you see this. Whereas upon furnishing the discrepancies of the documents as produced before the enforcement officer, direction was
Yes.
given to the proprietor on 28th June. The notice
Yes,
which you have
yes,
already
yes.
shown me.
Yes,
Now,
Yes.
which was duly acknowledged by him.
yes.
Now it is also observed from the area EO report dated 28th June 2022 that the establishments are provided falsified information to available the documents and etc. Now, where is the consideration of the document submitted by him? Did he file or not? Your notice doesn't say that he hasn't filed.
that these documents earlier filed at the time of availing the scheme, but thereafter didn't file. Thereafter,
Your notice should have said that no, they have not responded to such notice.
Lordship, in spite Lordship, the recovery notice is clear. This is on the fourth paragraph. Fifth, whereas my Mrs. Bapi Electrics had availed 12% employees contribution such and such to the scheme. Whereas upon filing,
Did they? Have you filed in opposition?
Lordship, then I can file opposition because of the release to.
Kindly answer me the question that
Yes,
whether
yes,
they
yes.
filed the document in response to 28th June or not.
Milord, their order says that it has been filed.
The order says nothing.
Milord, kindly see the next paragraph. Milord, whereas the documents and other records of MS Bapi Electrical furnished by the establishment in connection with the ABRY scheme has been examined, and it is found.
When?
Milord, subsequent to this notice.
That's not said categorically. After whether these documents were submitted after the notice of 28th June or before they are considering the other documents.
Right, that's Milord, my instruction is there was a.
But you can't show that, yes, when you submit some documents, you must have approved in response to your notice
Milord,
submitting all these documents.
Milord, a hearing or a meeting, whichever way Milord wants to look at it, Milord was convened in the office of the area.
Where have you said that, yes, I submitted all the documents?
Yes, Milord,
In response to 20th June notice? For your response to 20th June notice.
Milord, para 16.
What have you said?
The petitioner submits that since the respondent authorities, after having considered the petitioner as an eligible establishment under the scheme and having disbursed certain amount as indicated above, was seeking to question the bona fide and genuineness of the petitioner itself, the petitioner had submitted numerous documents, wherefrom it shall clearly evident that the actions of the respondent authorities. Milord, this is 15, Milord, I have said, 15 I have said that this document which they are referring to, the notice calling for documents. In para 16, Milord, I have stated on oath that in response to that notice, these documents were submitted to
Where
them.
is the line in response to the notice? Everyone.
Milord, numerous documents wherefrom it shall clearly evident that the actions of the.
But you don't say that, yes, I responded to the notice. The normal amendment would have been that, yes, I received the notice,
Milord,
I gave a reply on such and such.
Milord, para 17 also, Milord, I have stated that having considered such documents submitted by the petitioner, there could not have been any occasion for the respondent authorities to further harass the petitioner.
28th June, this page 87, the last para. He is directed, you are therefore directed to clarify the above discrepancy as relevant of the documents produced by you. You reply clarification supported by relevant evidence should be submitted within 3 days. This letter already been said, they have been asked to produce some documents.
No, you file your report. You are appearing for? Which respondent is this?
So, Milord, let us assume that no document was submitted. Milord, even then, is this recovery notice justified?
No, that you should have disclosed all this. If you don't disclose.
Milord, I have stated on note that these documents which is there at annexure P5, Milord, what I have shown to your lordship was submitted.
Your respondent number?
1 to 5, Lordship.
Respondent number 1 to 5 shall file an affidavit in response to the allegations made in the writ petition within a period of 2 weeks from date. The affidavit should specifically disclose as to whether the petitioner made any response to the notice dated June 28,
2022.
2022. June 2022. Release this matter up to 2 weeks under the same heading.
Milord, at least Milord, stay this
It doesn't appear,
attachment
Mr.
order.
Ghosh. Mr. Ghosh, it doesn't appear that you have responded.
Milord, even if
Milord,
kindly Milord, consider this. Even if I say that, yes, I have not submitted the documents, the recovery notice was justified. Let that be, Milord, in force. Milord, is this, Milord, notice for freezing my account justified?
Why not?
There is no 7A order under the Act.
Not necessary. This is not a PA proceedings as such.
Milord, they are exercising powers under the 1952 Act.
This is a scheme. This is a scheme. It appears that you have misappropriated the fund.
It appears, Milord, where is the recording that there is a falsification? Milord, all fake statements.
If you don't respond, they are entitled to hold this expert.
Milord,
show me your response.
Milord, I have stated on note, Milord, it was handed over to them.
That is not, affirmation is not also very clear. Neither there is any document, not the affirmation specifically says that in response to the 20th June notice, I have disclosed all these documents.
Milord, kindly see my pleadings. Milord, even if it is not being stated in clear terms, Milord, pursuant to the notice, Milord, I have stated that I have submitted those documents annexed.
No, you never said that in response to that notice.
Milord, in response to that specific, what is not there?
The way vaguely the impugn notice is drafted, the same vagueness is in the pleading. From the document submitted by them. At one point of time, you submitted various documents at many stages, at different stages.
Milord, kindly, Milord, at least
for 2 weeks.
freeze. Milord, at least the freeze.
You should produce all the documents before you committed authority. Then the entire matter.
But your notice is also equally vague.
Lordship, because of the.
You should have said that yes, thereafter they did make no response. Therefore, I hold that yes, they have no defense.
On that point, I am to the only so this is this scheme he is availed, but that has been.
Let the affidavit come, we'll say, yes, call the next.
Millard, for a moment, paragraph 15, Millard, 15 I have stated. Since the petitioner was acting in a bona fide manner, the petitioner with due sincerity submitted all such documents which were available with them. In the paragraph prior to that, Millard, I have annexed the notice, which was Millard, their notice, which has been shown to your lordship.
Where will you
28th
consider after 2 weeks? Let the report come, we'll see.
Millard, at least Millard, the
Not at this
freeze,
stage.
Millard.
Not at this stage, wait for 2 weeks, we'll see. Yes,
Grateful.
under the same meeting.
Same matter. Same matter, no?
Same order.
Millard, it's a same matter, Millard. It's a same matter, Millard.
Same notice.
Same Millard, same recovery notice, Millard, absolutely cut, copy, paste. But here, Millard, there is, Millard, no freeze on the bank. Millard, I am only
the
Millard
recovery.
against the recovery notice.
Very well, we'll see the same order also.
Item 22. Same order, Lordship.
Same order.
Gift of Lordship. Item 22.
It's not a recovery within the meaning of that Provident Fund Act.
Lordship. Because of the recovery, actually, the scheme has been empowered. The scheme has been empowered to the authority that is the you or the guidance.
Millard, I dispute that.
No.
I dispute that. I say that the scheme has nowhere delegated. Millard,
numerous occasions in this.
but this point was not considered by this honorable court. Millard, with deepest respect, a statutory power cannot be delegated by you for scheme.
Need not be statutory power, Mr. Ghosh.
Millard,
The scheme floated. The scheme floated. There must be something in the scheme that in the event.
even the scheme does not clearly, Millard, delegate the power
What the
upon them
scheme
to
says, what the
initiate.
scheme
Millard, kindly cease.
What the scheme says.
Millard, let them show one line where the power has been delegated upon them.
No.
To issue proceedings under the 1952.
Scheme has carried by the 1952 way. Enter scheme.
That is the reason I was submitting, Millard.
That is it.
Without an order under 7A, you cannot initiate a recovery proceeding. It's a self-contradictory submission which they are making.
This scheme is a
7A applies when an establishment fails to give his share of contribution. His share of contribution.
Yes.
But
Here, the entire Provident Fund scheme has been modified by
central government.
central government contributing the share of the employer as well as the employer.
Right.
So this is not a notice under 7A.
Correct.
This is not a notice under 7A and it need not be a notice under 7A.
Right.
Thing is this, if you misutilize the fund put it under the scheme, it should be within the authority to stop you from abusing the process of the scheme.
Right. That
7A need not be invoked.
Millard, that stopping of the abuse of process must be in accordance with law.
According to the principle of natural justice will do, Mr. Ghosh.
You're right. I am on principle of natural justice. Millard, in the recovery notice,
Since the pleading is not very clear, specific, we need to see.
without recording it in one line finding whether the falsification has happened.
If you don't respond, then their obligation to the present and all this to a great extent dilutes.
Because of scheme is only one point, the entire burden is shifted upon the employer. That is the
No.
employer's responsibility.
First of all, these are all stereotype mechanical orders, which reflects your non-application of fine. You cannot deal each and every case with the same kind of stereotype order. You should have dealt with each and every case individually, which reflects your non-application of fine. You appears to have relied upon a report. Have you given the copy of the report upon Mr. Ghosh's client?
Report in respect of the whatever I find from them. Because no, I have asked for to supply the copy. That this
Report, where is the report? You relied on the report. You carried out an inspection or investigation.
that is within me.
Have you given it to them?
So I think that also been supplied. I think that has been communicated.
So there are some procedural latches. But since.
Milord, in the next matter, Milord, I have disclosed that in response to their, Milord, the same manner, they have served a notice. Subsequently, Milord, all the documents were submitted, which is an annexure D5.
Show me.
Milord, para 16 again, Milord, 32.
32, no.
32 now, 14, Milord.
14.
Yes.
14, the same order has been.
14th already.
Already this Milord has already passed.
Yes, we'll see on the next. Yes. 14. Similar order has been passed with regard to 14 to
13 and 14.
13 and 14. Yes. 22. Who is in 22? 22. Who is 22? কি হলো? 14 এর পরে বাকিগুলো কি হলো? 15, 16, 17, 18 গুলো কি হলো? ফার্স্ট হাফ হয়ে গেছে। হ্যাঁ 22, 32 দেখাচ্ছেন কেন? কবে? You are in 22?
No, Milord, 32. My candidate make it not today.
22 ফার্স্ট কলে কি হয়েছে? পাস হচ্ছে। Yes. এখনো আসছে না, কে লয়ার কে? সে এখন আসতে বললো সৈয়দ জুলফিকার আলী। Not today. Not today. Sure.
The eve of lordship may be permitted mention of civil division for the extension of lordship, no, what have expanded.
Really?
Wait. Good.